Ed, Ms. Squally, your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Today's video features a courtroom clip from a YouTube channel called Time Served, which regularly uploads real courtroom moments involving unusual defendants and strange legal arguments. In this particular case, the man in court is claiming to be a sovereign citizen, a group of people who often argue that government laws do not apply to them. However, that's not the only strange argument he makes. He also claims that he should not be held responsible for trespassing because he was extremely drunk at the time. So instead of denying the crime, he basically admits that he did it, but believes his intoxication somehow excuses him from punishment. If you enjoy watching unusual court cases and bizarre legal arguments like this, you might want to check out the Time Served channel. They post similar content regularly, and you can find the link to their channel in the description. Now, let's begin watching the clip.
And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
Langley
I
go.
read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, though that language doesn't make any sense. So
no, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's
I'm not a person. I am one of the people. Thank you.
According to Merriam-Webster, one of the definitions of the word people refers to a group or body of individuals. In simple terms, if you are part of a group of human beings, then by definition you are considered a person. So when someone tries to claim that they are one of the people but not a person, it doesn't really make sense. The logic simply falls apart because the definitions contradict that argument. In other words, if you're part of the people, then yes, you're still a person. Maybe not the brightest person, but still a person nonetheless.
Okay, thank you. All right. So for the record, that's my finding. Yeah, hold on, we're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable.
I have to be completely honest here. In all the courtroom videos I've watched, this might be the first time I've ever heard someone use this particular defense. Usually defendants try to argue that they didn't commit the crime, or that the evidence against them is weak, or that there were misunderstandings involved. But this guy takes a completely different approach. Instead of denying anything, he basically says, yes, I did commit the crime, but I was so drunk that I shouldn't be punished for it. That's a very unusual argument. Admitting guilt while simultaneously claiming that intoxication should protect you from consequences is definitely not a common legal strategy.
Officer advised Mr. Milton that he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Nisqually jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or on the assault case?
Based on the new law violation, yes.
Thank you. And let's see.
Now, will I get a moment here to articulate anything?
Don't worry, you'll get your opportunity to speak in a moment. For now, however, the judge and the attorneys are having a discussion about the case. Think of it as the adults in the room handling the serious legal matters before allowing the defendant to jump in and say something that might make the situation even worse.
I'll let you know. So sit tight. I'm still working through the process.
Of course.
All right. So, Ms. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. Well, I will. And Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
When it comes to the whole sovereign citizen idea, I can't really confirm or deny anything about it. I'm not a lawyer, and I don't hold a law degree. My legal education is basically non-existent. The only joke I can make about it is that I slept outside a Holiday Inn Express last night, which is a humorous way of saying that someone is pretending to be knowledgeable even though they're not actually qualified.
Okay. So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them, I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay, even though the right term. Okay. All right. I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cams.
This is one of those moments where every attorney watching the video is probably shaking their head in frustration or banging their forehead on the keyboard. Any licensed lawyer sitting in that courtroom would already know how to properly request discovery, which is the process of asking the prosecution to provide the evidence they plan to use in the case. It's a basic part of legal procedure. A real attorney would also know that police officers are not required to read someone their Miranda rights at the exact moment they arrest them. Miranda rights mainly apply when the police plan to question you while you are in custody, and they relate to the admissibility of anything you say after the arrest. But many people misunderstand this rule and think that if the police didn't read the rights immediately, the arrest itself becomes invalid, which is not how the law works.
Like I said, I can't represent you. You're going to have to figure all that out yourself for purposes of today.
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights?
Did I read my form? I don't believe I was provided anything.
Okay. Is there a corrections officer there?
Mr. Upton?
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay. Why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
He claims that there were no victims involved in his actions. But that's not really accurate. The employees and owners of the 7-Eleven store he refused to leave were definitely affected by his behavior. From their perspective, they had someone inside their business causing a disturbance and refusing to leave when asked. I doubt they enjoyed dealing with that situation, and it certainly didn't help their business to have someone intoxicated and behaving like rules and consequences didn't apply to him.
I know. All I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so with the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance. And the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay. Anything else?
That's it for now.
Okay.
That moment in court was actually his one chance to argue against the prosecution's recommendation that he remain in jail under 2 separate $500 bonds. Instead of calmly explaining why he should be released, he spent the entire time making irrelevant statements and strange arguments. He had the opportunity to present a reasonable case for himself, but he completely wasted it by talking about everything except the issue the judge needed to hear about.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights, and I wasn't taking a statement from in both questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Oh, I was never aware of that.
Right. Which is one of the reasons don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay. All right. Seem like a sharp guy. So
Expanded rewrite to put it bluntly, this guy doesn't seem particularly sharp. If intelligence were measured like sharpness, he'd probably rank somewhere around a box of old, worn-down crayons. Definitely not the sharpest tool available.
Appreciate you, Your Honor.
seem dedicated to it. Okay. Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol and marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is 300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
And at one point, he tries to talk about the bond amount and the math involved, but his calculation is completely wrong. 10% of 500 is 50. Since there are two 500 bonds, the total 10% payment would be 100, not 300 like he claims. His misunderstanding of basic math seems to match his misunderstanding of legal procedures. Ironically, if the legal system didn't exist to handle cases like this properly, someone making arguments like his might never get out of jail.
Okay. Well, you may know from your history that the bail here is usually 10% of what's ordered. So $50 on each case is what a bonding company would want from you. So just, I don't know whether that
Well, I have
changes anything.
$100. Isn't that
Okay. All right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon. So on Monday, the 24th of April, for what we call a pretrial, Mr. Milton. And at the pretrial hearing, you will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it. But they will be contacting you to give you whatever offer they have. And then you'll tell the court at that time whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
Awesome. In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail. So you're going to have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right. I'm not going to write it as a court order. Like I say, I don't mess with how the jails run their jail, but
speaking of, by the way,
Mr. Sharp has heard you, and we'll go forward
on a side note, if I may, Your Honor, during intake, and I might preface this with, I have gone to anti-kidnapping training.
He also claims that he has received training in anti-kidnapping techniques, which is a strange thing to bring up while sitting in jail. If he truly had that kind of training, you'd think he might be able to explain how it's helping him right now while he's being held in the county jail facility.
I was inhumanely subject to what I would define as torturous actions. It was by C.O. Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal. And I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused. And told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour. So,
All right, we got that.
Yep, appreciate you.
Thank you. And we'll see you on the 24th.
And with that, we've reached the end of today's video. It seems like the next time this particular defendant appears in court will be in a couple of weeks, so we'll have to wait and see what happens next in the case. In the meantime, if you enjoy watching unusual courtroom moments and bizarre legal arguments, you should definitely check out the Time Served channel. They have a large collection of similar court clips that are both entertaining and surprising. If you liked this video, make sure to leave a like. If you didn't like it, you can leave a dislike as well, but either way, don't forget to leave a comment sharing your thoughts. Also consider subscribing and turning on notifications so you won't miss any future content.